Good evening, ladies and gentlemen. I'm Greg Rogers, Chair of the Business Law Section of the Law Council of Australia. On behalf of the section and the Australian Competition and Consumer Commission, welcome and thank you for joining us to hear our very special guest this evening. Before starting our program this evening, I wish to acknowledge the traditional owners and custodians of country throughout Australia and recognise their continuing connection to the land, sea and community. We pay our respects to them and their cultures and to their elders past, present and future. This evening is one of the most important events on the BLS calendar, which celebrates the deep connection we have with the ACCC. The submission to the Law Council in 1980, seeking to establish a business law section, was co-authored by Graham Samuel, who became the very first chair of the BLS in 1980 and 81. Of course, Graham went on to become the fifth chair of the ACCC. The late Professor Bob Baxt was our BLS chair from 2001 to 2003 and a member of our executive for more than 30 years, right up until his passing in March 2018. Bob was the third chair of the Trade Practice Commission from 88 to 91. Stephen Ridgway, a current commissioner of the ACCC, was on our BLS executive for several years and has had a hand in the organisation of this very event. Stephen was chair of our Competition and Consumer Committee for some years and continued his involvement in the committee right up until his appointment to the ACCC. Another notable person in our shared history is former ACCC Commissioner Roger Featherston, who in fact will be introducing our guest speaker this evening. He was chair of the BLS from 97 to 99, continued to be an active contributor to the Competition and Consumer Committee, and did an enormous amount of work in helping young practitioners through our Rising Stars workshops. One of the purposes of the BLS is the promotion of professional discussion, consultation, and study of aspects of laws affecting business and corporate activity in Australia. One of the strategies we do to achieve this objective is to bestow scholarships and prizes for worthy academic writing in relevant fields of learning. And on that note, I'm honoured to acknowledge the recipients of two of our scholarship prizes this evening. The Gare Blunt Scholarship is offered by the BLS for papers authored by young lawyers on a topic in the field of competition law. First awarded in 2008, it commemorates Gare Blunt, a leading competition laws practitioner who was in the vanguard of those who were to shape the form, regulation and administration of competition law in Australia. He was a member of our inaugural Trade Practices Committee of the BLS, and this scholarship recognises the role Gare played in developing and mentoring the careers of many young lawyers in this field. The 2020 Gare Blunt Scholarship was awarded to Denise Kayers. Her paper was entitled, Do Androids Dream of Electronic Collusion? An analysis of algorithmic collusion under Australian law, in which she concludes that current statutory provisions may not be capable of overcoming the challenges associated with detecting, investigating and litigating algorithm-enabled cooperation between firms. Denise is a lawyer in the Competition, Consumer and Regulatory team at Allens. The other prize winner I wish to acknowledge this evening is the recipient of the Baxt Prize, which honours the contribution of Professor Bob Baxt to business law in Australia, his long-standing involvement with and commitment to the BLS. He practised and published extensively in the fields of trade practices, corporate law and taxation law, and had a long-standing commitment to legal education. The 2020 Baxt Prize was awarded to Joshua Anderson for his article published in the Australian Journal of Corporate Law titled Directorial Liability for Inappropriate Employee Remuneration Schemes. Joshua is currently a Senior Associate in the Disputes and Investigations team at Allens. So thank you to both of those award recipients for their splendid work in this round of scholarships. I now wish to hand over to our very good friend Roger Featherston, who will introduce our guest speaker this evening.
Thank you, Greg, and good evening all. Tonight's lecture is in honour of Ron Bannerman AO, the first chairman of the Trade Practices Commission. And I'd first like to welcome his three children who are, I understand, on the call this evening, Marilyn, Bruce and Sally, and also a granddaughter, Lisa, who's joining us from Switzerland. Ron Bannerman started working in the Deputy Crown Solicitor's office in Sydney in 1938 when he was just 16 years old. He studied law at Sydney University and became a respected litigator across a wide range of legal subjects before being promoted and transferred to the Attorney General's Department in Canberra as an Assistant Secretary in 1962. At the end of 1965, the Trade Practices Act became law, and in 1966, Ron was appointed as the first Commissioner of Trade Practices. Ron remained as Commissioner of Trade Practices for 8 years until the 1974 Act was passed, and he was appointed as the first Chairman of the new Trade Practices Commission. He held that position for a further 10 years until he retired at the end of 1984. Ron died in 2013. It is hard to imagine now the magnitude of the changes in business practices that Ron was involved in through his implementation of the Trade Practices laws. In 1965, industry agreements restricting competition were the norm, and when the 1974 Act commenced, the Commission was inundated with thousands of applications for exemptions in the form of authorisations or clearances. Ron therefore had the task of seeking to change established business practices by educating business and enforcing laws that were far-reaching and not well understood. He also had to contend with the legal challenges to the Act, constant lobbying by business groups, and numerous parliamentary reviews and legislative amendments. It took the Commission many years to work through those thousands of applications for exemption, and that was a very heavy burden for the Commission. But Ron looked at it philosophically as an opportunity to apply and explain the law through the publication of the Commission's decisions and its reasons, and to have its decisions subject to appeal to the tribunal. Notwithstanding all the work on exemptions, the Commission through this period also pursued active enforcement strategies in both competition and consumer law matters. Ron believed that administrative outcomes were more efficient, but he recognised the importance of taking some matters to court, particularly where they involved large corporations, as a demonstration to others. Ron rose to all of these challenges and successfully built the practices and policies of the Commission, many of which are still largely in place with our current Commission, the ACCC, which replaced the TPC in 1995. Through his integrity and his careful and reasoned approach to the administration of the Act, Ron Bannerman not only made the Commission an effective enforcement agency, he also won respect for the Commission in both business and government circles. Ron was a calm and considered person. He was always extremely polite and quietly spoken, even on those few occasions when he was upset or angry. He led by example, but he also led by empowering and training those working for the Commission and by fostering a strong team spirit. I was a beneficiary of his approach because I spent the first 4 years of my legal career acting for the newly established Trade Practices Commission. And one of the practices that Ron established and that continues to today is to have weekly meetings of commissioners. At those meetings, as each matter was considered, Ron would ask the lawyer acting on that matter for their advice. And so despite my inexperience in 1975 and his own enormous legal experience, Ron would follow his practice and patiently ask me for my legal opinion and then politely question me. He'd then go around the room and ask each of the commissioners for their view before expressing his own view, which of course did not always accord with mine. It was indicative of his charm and humility, but he wasn't a soft touch. He was determined and could be firm, and he usually achieved agreement on the strategy or action which he favoured. I'm pleased that this annual lecture is held in memory of Ron Bannerman and his achievements as Commissioner of Trade Practices and Chairman of the Trade Practices Commission. And tonight we're very privileged to have as our guest speaker, Dr Andrea Coscelli, who is the Chief Executive of the Competition and Markets Authority in the United Kingdom, and who will be speaking to us from England. Andrea has been Chief Executive of the CMA since July 2016, and for 3 years before that, he headed the Directorate at the CMA, responsible for UK merger control the markets regime, and the CMA's work in regulated sectors. He joined the CMA from Ofcom, where he was Director of Economic Analysis. He previously worked at Charles River Associates in London, and he holds a PhD from Stanford University. I understand that Andrea will be discussing the potential under-enforcement of competition laws as a result of conservative economic principles and the need to take a bolder, more aggressive approach. Although Ron Bannerman is no longer with us, I believe he would have welcomed the subject of tonight's lecture because he was always pushing the boundaries for more effective enforcement of the competition laws. This is also a subject close to my heart, and tonight it comes with the bonus for me of an economist explaining why economists may have led us astray. So Andrea, welcome. Good morning to you, and the floor is yours.
Good evening, everyone. Thank you very much for the nice introduction, and thank you very much for the invitation. It's really a pleasure to be here this evening. So let me start with Ron Bannerman. As you just said, from what I've seen, he was clearly a pioneer and a forward thinker. And it seems self-evident now that the business cartels he confronted caused harm to Australian consumers and the economy. By his work over 2 decades to cut back at what he later described as the astonishing web of restrictions across Australian industry was conducted in the face of considerable resistance and antagonism. The ACCC, in my experience, has continued that legacy of leading from the front. Under the chairmanship of Rod Sims, has done pioneering work on digital markets, more recently, and generally on competition and consumer protection. And the work of the ACCC has had a very significant influence on what we have been doing over the last few years. So how competition authorities stay ahead of the curve, how we deploy our current toolkit, and the additional tools we might need in order to deliver for consumers are what I want to talk about this evening. Operating as we do predominantly at the level of individual firms and transactions, I think it's easy to lose sight of the wider importance of the work we do. A robust and timely intervention to address problems with conduct or anti-competitive mergers carries wider economic benefits. We know that. Stronger productivity, lower inequality. I mean, these are things that are important at the best of times. As our economies hopefully begin to recover from the pandemic, these issues will become more important than ever. So how do we stay ahead of the curve as competition authorities, as markets and business practices evolve ever more quickly? Some might say that we know the answer already, that despite different starting points, there has been very extensive international convergence over the last 20 to 30 years. And to some extent, this is true. And it's been based essentially on 3 core principles. The first is that economic analysis should sit at the heart of the assessment. So whether particular conduct is problematic or whether particular merger should be prevented. And this analysis should very much focus on consumer welfare. This is reflected in the institutional design of many of the international competition authorities, particularly competition authorities that were created by the respective parliaments during the 1990s and the 2000s. And that's certainly the situation in the UK, where the most important act came in the early 2000s. The second principle is that we should be cautious in the face of uncertainty. And this is the concern about over-enforcement and the risk of chilling and deterring investment and innovation. And the third principle is that competitive markets should be preferable to regulation whenever we can. Or as Ron Bannerman himself would have said, competition itself is an important regulator. Now, I think it's now widely agreed that the consensus around these principles is showing signs of fracture. There are calls from many parts in our parliament, in many parliaments around the world, for competition authorities to look beyond consumer welfare and take other objectives into account. There are arguments that have been overcautious and too narrow in our assessments. And the case is increasingly made that many markets, particularly a number of digital markets, are underregulated. There are a number of possible reasons for this shift in thinking. One of the most important explanations, to my mind, goes back to my theme, that as the digital revolution has transformed markets, competition authorities have struggled to stay ahead of the curve. The largest digital platforms have acquired very significant market power in a number of very important markets. And the web of restrictions I was talking about earlier is present by new ways, such as algorithmic collusion or anti-competitive self-preferencing by platforms or acquisitions of startups or nascent rivals. And we're struggling to address these concerns in a timely and effective way. So I would like to say a few words of where we stand at the CMA on those principles. I would say at the outset that I think the three principles individually remain relevant, and individually they're not necessarily wrong, but I think the problem is that in combination, they've led to a number of legitimate concerns given the evidence from the markets in front of us today. Externally, I think we need to look at whether we are empowered by the legislation that we apply to act sufficiently swiftly and effectively in the face of developments and behavior that stands to harm consumers. In the UK, at least, we think there is scope for improvement. We have said it publicly over the last couple of years. And internally, we need to look at whether we are taking the necessary risks, whether the lessons from the decisions made yesterday, particularly decisions not to intervene, are bearing as they should on decisions made today. For the CMA, this challenge to adapt and develop is given extra impetus now that, having left the EU, we have acquired the responsibility for major antitrust and mergers cases, many of which will be in the digital space. They were previously reserved to the European Commission. Turning to the first principle, that our decisions should be based on economic analysis of price, quality, innovation, and generally benefits to consumers in the short and long run. Economic analysis sits very much at the heart of our decisions at the CMA and will remain so. And I think it's right. We need to stay focused on consumer interest and whether consumers stand to gain or to lose. This is our current statutory duty. If, as some suggest, we ask competition authorities like us to focus on other objectives, such as the protection of workers, or the promotion of small businesses, or contribution to industrial strategy, then we must face up to the question, what happens when those objectives come into conflict? What do we do when a merger is bad for consumers, but potentially good for jobs in a particular industry? These are not easy questions, and many would contend non-appropriate questions for independent competition authorities staffed by unelected officials to answer. At the same time, I want to be clear that we think it's very important that consumer welfare should be interpreted broadly. Non-price factors such as price and innovation, concerns about privacy in digital markets, I think these are core to our assessments in a number of markets. Even an issue like the security and resilience of supply chains, an issue that's become increasingly important, unfortunately, over the last 12 months, is something that could form part of our consideration under our current legislative framework, to the extent it affects consumers over time. So I don't think we should shift our focus away from consumers, but I think it's important that we constantly question whether we are doing all we can to deliver on the terms that we've been set. And I think here there is scope for improvement. So for instance, if you look at the way we currently look at mergers or antitrust cases, and very much similar way to many others, including the ACCC, most of the evidence we consider comes from the affected businesses and their advisors. And the evidence is increasingly extensive, increasingly complex, as extensive economic analysis, and obviously makes the case that a particular merger is not problematic for consumers. And obviously, we apply due skepticism to this analysis. But I think the problem is that the consumer voice in these proceedings that are becoming increasingly complex and you would argue technocratic, the consumer voice in this process is largely silent. And that consumer voice is even more absent during litigation, where the competition authority is defending their decisions against the appellants. And I think that creates some issues. The first one, I think, is an issue of legitimacy. There is increasingly a concern that consumers systematically do badly out of the current competition regime because they're not in the room, they're not part of the discussion. And the second one is whether all of the relevant evidence is in front of us as an authority deciding a particular matter in front of a court. And I think, again, not having consumers or consumer representatives as part of those discussions sometimes might mean that some relevant evidence is not part of the discussion. So I think that's something that needs to be thought about. The other issue, I think, is the timeliness of interventions. In many ways, more and more markets are moving faster and faster, particularly with the digital economy. But if you look at the evidence internationally on enforcement activity, a lot of the cases are progressing more slowly. And in a number of cases, even successful interventions happen too late for some of the businesses at the receiving end of certain practices. What about the second principle? They should be cautious in the face of uncertainty. I mean, I would make two observations on this. The first one is that I think we have learned a great deal about digital markets in the last few years. And I think that's why we in the CMA, and I think the ACCC is in the same place, we feel confident to make a compelling case for pro-competitive regulatory intervention against the most powerful platforms to promote competition in a number of digital markets. We have also, on the merger space, we have carried out a number of reviews of our merger decisions to ensure that the lessons from past cases are brought to bear on our current work. And generally, we need to continue to develop our baseline understanding of these markets. And we've invested quite heavily on a data team in the CMA to help us with our understanding. And we've recently published some work on algorithms, again, very much as part of a program of work to further our understanding in these new areas. Secondly, I think we need to recognize that while a degree of uncertainty is inevitable, particularly when it comes to our merger assessments, we must acknowledge it, we must minimize it, but the presence cannot preclude us from acting. Wherever we act in the face of uncertainty will be a risk of over-enforcement, but it must be balanced against the risk of under-enforcement that comes from doing nothing. And I think we have learned in recent years that in many digital markets, the risk of consumer harm from under-enforcement is high. We know that many markets in this space can quickly tip towards monopoly. We know that can happen quickly, and we know that self-correction through market forces in at least some of these markets is unlikely. And the correction through antitrust enforcement is often too slow to avoid irreversible harm. In our recent advice before Christmas to the UK government about a pro-competitive regulatory framework for digital markets, we've also made recommendations about changes to the merger regime. We've asked the government to introduce a special merger regime that would apply only to the largest platforms, where we'll apply a more cautious standard of review to, in our view, level the playing field in the face of the uncertainty when reviewing some of these transactions. This is now for the UK government and Parliament to decide. In many ways, I think if you go back to the statistic that many people on this call would be familiar with, that between 2008 2018, there have been more than 400 acquisitions from the 5 largest digital platforms, Apple, Amazon, Google, Facebook, and Microsoft. And not a single one has been blocked by competition authorities. And in many ways, has not really changed since. As we see with the current Google Fitbit case that has been approved with remedies in many jurisdictions, not in Australia yet. And I think if you look at those numbers and you look at the evidence in front of us about how some of these markets operate, I think it's difficult with hindsight to believe that the balance has been struck correctly. And let me say just a few words on the third principle, which is that competition is preferable to regulation. I mean, I think as the head of a competition authority, I obviously believe it. And having had the benefit of working as a regulator for a number of years, I know regulation of complex, fast-moving markets is hard, and in many ways is not the first best. But it depends. You know, there are cases where, as a competition authority, we fight very hard to introduce competition in markets like legal services or pharmacies. But at the same time, well-designed pro-competitive regulation works in a number of markets, has been very successful in the telecoms industry over a number of years. We have recently introduced some pro-competitive regulation in the banking sector in the UK with open banking, with interoperability, which has been quite successful so far. So that's why, for us, like the ACCC, we have concluded that our current toolkit based on mergers and antitrust is insufficient to deal with the largest digital platforms. And this pro-competitive regulatory framework is needed. So we're very happy that the UK government has confirmed that from the 1st of April of this year, there will be a digital markets unit in the CMA, initially in shadow form, and then hopefully once Parliament passes the legislation, we'll have the new powers we've been asking for. And we're working hard in the meantime, using our existing powers to improve outcomes in the sector. And we've today published a refresh of our digital market strategy to set out what we're planning to do this year. I also want to very briefly mention consumer protection, which is a very core part of what we do, like the ACCC, and a lot of our work recently has been in digital markets. And we see it as a very important complement to the work we do on the competition side. And our recent case work has had very significant overlaps with the work of the ACCC in areas like fake and misleading online reviews or on secondary ticketing platforms, where some of the commercial practices we have seen, we think have been problematic for consumers, and we've been able to intervene. So let me just conclude with my final point, which is about international cooperation. It's the first time in history that competition authorities are dealing with a number of players which have very, very strong positions, you could say monopoly type positions in very important markets nationally. But the same is happening globally, and the business model is the same globally. And it's very important to us that over the last couple of years, our own thinking in terms of adding pro-competitive regulation as a complement to ex-post antitrust intervention and to merger control in many ways has had very significant parallels to what the ACCC has been advocating in Australia. And it's also very important to us that the European Commission is currently planning very similar reforms for the EU 27. And in the US, the new Biden administration has also expressed an interest in legislative measures alongside enhanced enforcement by the competition authorities there. Now, the task is to achieve coherence. It's not going to be easy. We have some examples. If you look at the global banking sector post-2008, it's been a very strong focus on international cooperation in terms of dealing with large international banks, dealing with concerns about financial stabilities. And there are some lessons we can learn there. But in the meantime, and let me just conclude, we are working very well with ACCC. We have very similar issues to deal with, and we're constantly learning from each other. in terms of possible solutions that can help consumers in the UK and in Australia. Thank you very much for your attention.
Thank you very much, Dr. Coscelli, for those thought-provoking comments. As you say, we've seen some substantial developments and reforms over the last few years, reflecting what may be the most significant challenge to traditional theories of competition law in decades. And the next few years will no doubt be transformative ones in this space. It's time for questions. We've got about 15, 20 minutes for Dr. Coscelli and perhaps some for Rod Sims if anyone would like a bit of an Australian perspective or response to Dr. Coscelli. For those who don't know me, my name is Jackie Downs and I'm the chair of the Competition and Consumer Committee of the Law Council, and I'm moderating this question session. And on behalf of the committee, again, Dr. Coscelli, I'd like to thank you for your time today very much. We are very privileged that you're able to speak with us this morning, your time. So just some logistics. If you have a question, we prefer that you type it into the chat box rather than having, just given the time frame, having people speak on camera. So please pop your chat to everybody in the chat box. It would be helpful if you could include your full name and where you're from. So we can attribute that for Dr. Coscelli or Rod Sims. I'll read out the questions. We may or may not have time for all of them, so please don't be offended if your question doesn't make it to the floor this evening, but we will certainly try our best. So look, while we're waiting for some questions, Dr. Coscelli, I might kick off with one of my own. You mentioned the absence of the consumer voice increasingly in this forum. And I think we've seen increasingly in these issues, the intersection and perhaps conflict between different types of consumer matters or different matters affecting consumers. For example, privacy versus competition. And I think from the Australian perspective, and I think you highlighted as well in your report, we're seeing this particularly in the interim AdTech report in the AdTech space, where there are issues being raised about the importance of consumer privacy, but that may actually be impacting on interoperability and sharing of information and competition. How do you reconcile these different aspects of consumer welfare, if you like, when you're assessing these issues?
It's a very good question. In many ways, I think it is one of the challenges we have at the moment. So we launched literally a few weeks ago an antitrust case against Google in the UK in the context of some of their plans for their privacy sandbox, which is about essentially trying to increase privacy for all of us as consumers, but the issue there is that it will potentially have some detrimental impact on some of the competitors and have a differential impact to them and to others. And so in practical terms, we're working extremely closely with the Information Commissioner's Office in the UK, so our privacy regulator. We very much have essentially joint teams to look at these. I think ultimately, this joint effort is to narrow down the number of plausible options for something where essentially there are trade-offs between competition, consumer aspects, and privacy. I mean, one way of thinking about it in many areas for us is when we deal with sector regulators or regulated areas, is that essentially you have to take the particular regulation as a given and kind of work on competition at the margin. In areas like privacy, where regulation is also evolving in parallel, it is a bit more complicated, and that's why I think it is a challenge. But I think generally, if you think about more stable sectors like pharmaceuticals or financial services, these are areas where there is very detailed regulation that has an impact on competition, but we've learned to do it in parallel, essentially, with the relevant regulators.
Yeah, thanks. I don't know, Rod, do you have a comment from the Australian perspective on this issue?
Oh, only, Jackie, that I think we would look at, if a if there could be competition in privacy, that is to say one provider is offering a lot more privacy than another, then that would be relevant in a competition context. In the consumer context, we're just really focused on are consumers misled, and we try and leave the privacy issues for the Privacy Commissioner. But clearly there's overlap, as Andrea says, and we have regular meetings with the Privacy Commissioner. If an issue is unclear, then we work out whose territory it is. But certainly the cases we have taken, the Google location matter, there was a lot of talk that that was a privacy case. Well, for us, it was very clear that was misleading conduct. So we're not, so far, I don't think I found it too difficult to make that differentiation. And the Privacy Commissioner has also taken their own cases. I think in Australia, we need, and I'm sure the Privacy Commissioner would 1000% agree, we probably need the Privacy Commissioner to be resourced to the task that privacy now presents for Australian society. And I hope that's going to come. We'll certainly be saying everything we can to politicians to get that to happen.
Thank you both. I have a question that was given to me by one of our committee members, Caroline Coots, who unfortunately couldn't join us this evening. But Dr. Coscelli, she wanted to ask about, I suppose, the potential divergence now between the CMA and the European Commission. And one sort of recent potential example of this is the undertakings in the Google Fitbit merger. Now, those were accepted by the European Commission, those behavioural undertakings. In fact, the ACCC rejected them as insufficient, as continuing to investigate the matter. And I think that generally the CMA has a similar view to the ACCC on behavioural undertakings. Do you think there's a potential for some divergence there between the CMA and European Commission going forward?
Well, I think so. You're right. We have been quite clear in our reports that we were quite skeptical about this type of complex, long-running behavioral undertakings that require quite a lot of monitoring, and we have rejected similar undertakings in cases over the years in the UK. I mean, I think we are in a very similar place generally, I would say, to the ACCC, which is that when you look at global mergers, you try quite hard to work with others and land in a similar place on a package of remedies. At the same time, there might be instances where you are in a different place from others. And I think we, it is one of the consequences of Brexit, and now we can take decisions independently. So I think we probably have a similar approach to the ACCC, where if we think certain remedies are not good enough for us, then that's where what we will do in future.
We have a question from Marcus Betsy from the ACCC. He notes, as you say, issues that impact competition and consumers in the digital economy cross international borders. Are existing tools for cross-jurisdictional cooperation sufficient in your view, Dr. Coscelli? If not, what more needs to be done?
Yeah, I don't think they are sufficient. I think we are dealing for the first time with, this kind of unprecedented challenge of having essentially global monopolies in a number of areas. So there is quite a lot of work going on these, lots of discussions, and it's a combination, I think, of having the right international fora and have the right discussions and doing things together, and potentially working on some of the legal frameworks at the national level to allow for this enhanced cooperation. I mean, one of the specific issues we have in the UK at the moment is that we were part of a very well integrated network with the European Commission and the other European competition authorities. And with Brexit at the moment, we have a gap because essentially we have lost the ability to exchange confidential information. So for us, this is now one of our priorities. I mean, it's in the hands of the UK government because it needs to be done at the government level. But certainly we have said quite publicly that it's a priority for us to do that. And ideally, we'd like to extend that to other agencies outside Europe if we can.
Rod, any comment from you?
As the person who asked the question would expect me to say, Jackie, we need much more ability to pass documents between each other and to help each other question, examine potential witnesses. We've got a great arrangement with the US, and we'd like to, we've just signed that MMAC deal, but we'd like to extend that as widely as we possibly can. So we look forward to working with the CMA as much as we can to try and bring that about internationally.
We have another question from Nick Kerr, another one of our ACCC commissioners. Dr. Coscelli, does your comment regarding the need for special regulatory measures for the large digital corporations suggest conventional economic analysis is not adequate in markets involving significant intangible elements?
Yeah, I mean, I think the background to us about this request for a special merger regime is that we are worried partially about information asymmetry, particularly when you're looking at the largest digital platforms buying early stage companies. And secondly, we're worried about the legal standards in court, where a lot of the case law on merger control is based on mergers in more traditional and more stable industries, where in a sense you could quite reliably look at the evidence from the 2 to 3 years before a merger in terms of data and documents and say, okay, this is, we're pretty confident in our prediction about what will happen over the next couple of years. We now know that for some of the acquisitions that have created some of the problems we see today in the markets, the evidence base at the time of the merger occurred was much more complex. There was a lot of uncertainty, lots of scenarios, different people thinking about different things, different projections. And we think there is a risk of under-enforcement because either ourselves or the courts will conclude that on the balance of probabilities, the likelihood of harm has not been proven. And so we have been very open. This is at the end of the day a democratic decision for Parliament, whether we should be more cautious on this small subset of mergers. And we very much hope that our Parliament will agree. If they don't, we will use our current powers to the extent possible.
Just following on from that, Dr. Coscelli, I mean, clearly there's been, you've mentioned it, and many regulators have talked about this risk that there has been under-enforcement. But what about the risk of going the other way? What about the risk of over-enforcement that can have as damaging impact on the economy as under-enforcement? You mentioned getting the balance right. How do you think you can do that?
Yeah, I mean, obviously, we want to get the balance right because, we all believe in competition and growth and productivity, and we need growth and productivity even more than the usual in the next few years coming out of the pandemic. I think the empirical evidence is that over the last 10 years or so, there has been under-enforcement, both on mergers in many traditional industries. We see higher markups, and we see that in a number of industries, shareholders have done very well, consumers haven't. And then on digital, and then you have the intersection of mergers in the digital space. And, for instance, I read a very interesting book, which is called No Signal, which is about the acquisition of Instagram by Facebook by I think a Bloomberg journalist. And it's a book basically with, very detailed interviews with all the key participants at the time. And it really explains the discussions and the options available to Instagram and how that acquisition came about and the integration. And what was striking to me is that even if with hindsight, after a number of years, you read, a 300-page detailed book describing that particular acquisition, it's just very difficult, even with that information, which obviously you would not have at the time, it is very difficult to make that call. And the problem is when you have that uncertainty, historically, we've always said, well, it's just too difficult, too complicated, and we should err on the side of not intervening. And I think that's kind of where the balance went wrong, and where we need to correct it. But obviously, the correction only needs to go into the right balance. I mean, certainly no one has any interest in going towards over-enforcement, but I think we're pretty far away from that place at the moment.
Thank you. We have a question from Paul Evans of law firm Quinn Emanuel. It's quite a long one, I'll try and paraphrase. I think the question is really about, again, about these new business models of the digital platforms, and whether or not, again, looking at the Google Fitbit merger, but perhaps as an example, the CMA has a view on the efficacy of remedial provisions under existing competition laws. Are they sufficient to deal with incumbent platforms where anti-competitive conduct is found?
Yeah, I think we are worried about those powers, because in many ways, if you look at the experience of the European Commission, which has had a number of successful interventions using antitrust powers, that the view seems to be that the remedies have been the weak part. I mean, obviously, there have been large fines. And certainly, if you talk to the competitors, they are unhappy because it took a very long time, but B, they're also unhappy because they don't think the current remedies work. So I think that's a rationale for us to propose this ex-ante framework where you can step out from an extremely confrontational debate in the context of an active antitrust case and an active litigation to a discussion about forward look and the future rules of the road without liability, without fines, and much more about trying to set the boundaries of what appropriate competition should be, which is incidentally the way it works in wholesale financial markets. If you look at where we were in 2008 in wholesale financial markets, we realized lots of things had happened that shouldn't have happened. And competition authorities spent the following 3, 4, 5 years giving very large fines against large international banks. But then, we all switched to ex-ante regulation. And if you look at what has happened this year during the pandemic, this is a part of the economy that has not been particularly problematic because the rules have worked. And I think that's kind of where we need to go on digital platforms, to kind of have a framework that delivers without having this very aggressive litigation that is, what happens when you are in the context of an antitrust case. I don't think it's particularly suited for the sheer complexity and dynamism of some of these markets.
Just on that, the European Commission's new Digital Markets Act leaves scope for divestiture. What is your view? Do you think it's important to have those options for structural remedies, or is your new regulatory approach really trying to target and aiming to shape future behaviours through regulation?
I mean, I think structural options need to be on the table, because I think regulation is complicated and you need a degree of cooperation by the companies involved. So at the end of the day, I think what we should be interested in is the outcomes. If we can get to good enough outcomes in a reasonable time frame through regulation, great, I'll be very happy with it. If it doesn't happen, or it looks like it's not going to happen, I think we should definitely focus on structural options.
Thank you. I don't think we have any other questions. Last call for a quick question. Otherwise, Dr. Coscelli and also Rob, are there any closing remarks you'd like to make?
Well, I'll just, I know Sarah's going to do it anyway, but I certainly found a lot in Andrea's speech that I thought was terrific, very, very thoughtful, and much I agreed with Andrea. Thank you. But I know you're about to get a thank you, but since I was invited to say something, I'll say that. Thank you, Rod, and thanks a lot for inviting me.
Okay, well, look, I might close the session there. I'll hand over now to Sarah Court to officially close this evening and give our vote of thanks. Thanks, Sarah.
Well, good evening, everyone. For those of you who I haven't met, absolutely, I'm Sarah Court, one of the ACCC commissioners It's my privilege, Andrea, to give you a vote of thanks. I'm going to echo Rod's comments. I'm not sure, to be honest, if I'm comforted by your remarks or challenged by your remarks, and I'm sort of waning between the two. I was thinking about when we caught up in person, Andrea, on the last occasion, which seems like a very long time ago. It was in London. It was midwinter, and the world felt like a very different place than it is now. And I think sort of given that, I think it was 14, 15 months or so ago, just reflecting on your comments, as I say, am I comforted or am I challenged? In relation to the underlying principles that you've taken us through, the economic analysis sits at the heart of a regulator's approach, caution in the face of uncertainty, and competitive markets supported by active competition authorities are preferable to regulation. I think, as you said, those themes or principles do all remain relevant, but you've also raised a number of much harder issues, I think, for us to think about, and they are very common to those that we grapple with at the ACCC. Do we have the right legislation? Do we have the right powers? Are we taking enough risks? Are we under-enforcing? Are we over-enforcing? And some of your other observations I also very much identify with. You know, what should we strive to do differently? How do we introduce the consumer voice to our competition assessments? How do we accelerate our competition work, which just seems to get harder and more complex and more expensive all the time? There are other commonalities. We welcome the parallels with the establishment of your new digital markets unit. I think that's a really exciting development, and I know they'll work very closely with our own digital platforms branch. And it'll come to know as no surprise to people on this call tonight that the CMA is one of the agencies that we engage with most frequently at all levels across the organisation. It's a relationship of great importance and significance to us. And then just finally, as you concluded, strong international cooperation is just going to be essential to meeting the challenges of the digital world. And given the work that seems to be being undertaken in almost every jurisdiction around the globe that you can think of, we also recognise that importance of coherence and constructive and open relationships. The CMA has been a real leader in this regard, and we very much look forward to continuing our close work with you all. Now, just turning to this event itself, it would of course normally have taken place in Melbourne or in Sydney here in Australia. The COVID pandemic meant that that wasn't an option, and so for the first time we have moved the event online. So that's created a wonderful opportunity in some ways because we have secured an international speaker of the calibre of Andrea, but we've also been able to include a much wider audience than we're often able to. So I just particularly want to make welcome colleagues from competition agencies across the Southeast Asian region, agencies that participate with the ACCC in our CLIP program, the Competition Law Implementation Program. Just delighted that you can join us this evening. And as always with this lecture, I'm very pleased that we've been able to draw together such a range of regulators, policy makers, lawyers, economists, other thought leaders and participants from around the globe. And Andrea, your insights today have given us much to think about, and thank you again for taking the time to share those ideas with us. Now, to all of our guests that are dialed in from the UK, we will leave you to go and have a morning coffee and get on with the rest of your day. And to my colleagues in Australia and in Southeast Asia, you're at the other end of your day, you can go and mull over Andrea's comments with a glass of wine. So that brings us to a conclusion. Thank you all very much for attending, and thank you indeed, Andrea. Hopefully we'll get another coffee in person at some time in the not too distant.
Exactly. Thank you very much. Thanks.
Good night.